Hello everyone, welcome to my YouTube channel Judiciary 009. In this video, we will cover the fourth part of Companies Act 2013. In this video, I will cover Chapter 27 and Chapter 28, including leading and latest case laws. Chapter 27 talks about two types of authority, that is NCLT and NCLAT. And this chapter talks about a special court in which the court of session may be assigned as a special court, or additional session judge may be assigned as a special court, and there is also a judicial magistrate for some type of the offenses. That officer also having a jurisdiction to try some kind of cases. There is one leading case on chapter 27 and 28, that is a Madras Bar Association versus Union of India 2015. Whenever we made the Companies Act 2013, then we made two type of authority under chapter 27, that is NCLT and NCLAT. That is affirmed by Supreme Court, that is okay, that you can made that two types of authority, but struck down certain areas like section 409 clause 3 subclause 8 and C. The reasoning has also been given by the court, which says that a joint secretary level officer in this section, in this 409 clause 3 clause A and clause C, which says that a qualification of the technical members are fixed as the technical members may be a joint secretary level. Supreme Court struck down that officer's appointment. It says that the technical members must be a rank no less than secretary or additional secretary to ensure the possesses a status and competency nearly equal to the High Court justice. So, if we consider these authorities, like if we see, 1 minute. Let's see who is see NCLT and NCLAT. It is always presided by a president. There are two types of other members in this NCLT, that is, one is a judicial member, other is a technical member. President, presided by president. And in NCLAT there is a chairperson. One is a judicial member, other are a technical member. That is a tribunal was established. NCLT and NCLAT, there are three types of authorities mentioned in this tribunal. NCLT was presided by the president. NCLAT was presided by is to be presided by the chairperson. And when talk about the appointment of president, appointment of the chairman, it is always to be done under section 412. And that always appointment be made by the central government with the concurrence of Chief Justice of High Court, Chief Justice of India, President and Chairperson. Section 412 is very important with regard to that whenever there may be appointment after consultation or concurrence with the Chief Justice of India must be there. But whenever we are considering that a judicial member or a technical member that judicial members, that technical members, these always to be done by way of a certain committee. The president of the tribunal, chairperson, if we make a chart of it, that president, chairperson, and that judicial members, that three authorities under section 412 is to be appointed by consultation with the Chief Justice of India. These three authorities, two authority in NCLAT and one authority in NCLT, that is the president and here in chairperson and judicial member, always appointment made with the consultation of Chief Justice of India. Section 412 saying so. But if the appointment with regard to the technical members, appointment with regard to the judicial member and technical member of NCLT, these two authorities to be made only by a selection committee. Selection committee. In that selection committee, there must be a 4 members. There must be a 4 members. First is a Chief Justice of India or his nominee, considered as a chairperson of that selection committee. That senior judge of the Supreme Court or Chief Justice of that High Court must be a member. And third is a secretary in the Ministry of Corporate Affairs. And fourth is a secretary in the Ministry of Law and Justice. So there are 4 members, 2 are judicial member, 2 are executive member. So always priority should be given to the judicial member, that is Chief Justice of India, while making a selection. So technical member must have a 25 years of experience in NCLAT, but technical member in NCLT must having a 15 years of experience, or he may be additional secretary, he may be a secretary. Firstly, it was a joint secretary. Firstly, in 2013, it was made a joint secretary, but Madras Bar Association versus Union of India said that a joint secretary could not become a technical member, and they struck down that procedure. And now in 2018 amendment was made under this act. Now these types of selection process was made, and these types of authorities were assigned to the duties as a technical members. And additional secretary or there is a judicial member, and president must be a chairperson. The qualification of president and chairperson is also fixed. Chairperson may be a Supreme Court judge, or Chief Justice of High Court. He is or has been chairperson. The president of NCLT must be a High Court judge. Is or has been. But if you talk about the judicial members of NCLT, then judicial member may be a High Court judge, or he may be a district judge for working till 5 years, 5-year experience, or 10 year of experience of any advocate in any legal expertise. That is a qualification of a judicial member in NCLT. But a judicial member, the qualification of a judicial member in NCLT, NCLAT is not provided. So that is the issue which is very important to understand, because 412 is very technical and it is difficult to understand. So Madras Bar Association struck down 409 clause 3 subclause A to C in which the joint secretary level person may be eligible for the appointment of a technical member. That was struck down by the Supreme Court in this judgment and says only the secretary or additional secretary level person may be appointed as a technical member, not any other. And it also says that section 411 clause 3 was also struck down, in which it says that a similar NCLT qualification it lack necessary safeguard to ensure only individual with that the technical other technical members are maybe having a legal high level expertise and rank. That is very vague term, and that is why the section 411 clause 3rd was done away by Supreme Court. Thereafter the structure of a selection committee was also struck down by the Supreme Court under section 412 clause 2. Thereafter in 2018 amendment was made. Before amendment, the law was there must be a 5-member committee, and the executive given a majority. The 3 members was from executive executive authority, and 2 were the judicial authority. And there is no such primacy given to the Chief Justice of India in that casting vote, and that is why 412 clause 2 was done away, struck down by the Supreme Court. Thereafter, section 408 and 410 was upheld by the Supreme Court. It says that NCLT and NCLT is a good authorities, tribunals permitted to be run under Companies Law Act, and also affirmed that Parliament has a power to transfer jurisdiction from a High Court to specialized tribunals. So NCLT and NCLAT both having a power same as like the High Court. So they also the Supreme Court also upheld section 425, which says that the tribunal have a power to punish the contempt by their own self under Contempt of Court Act. Generally this power is given to the High Court and Supreme Court judges, but since 425 is made under Companies Act, which says that NCLT and NCLAT now have a power to punish a contempt as like the High Court under a Contempt Court Act. So this is already done. Now this is other judgment, Tata Consultancy Services Limited versus Cyrus Investment Private Limited 2021. Supreme Court, in this judgment, Supreme Court set aside NCLAT order and reinstated Cyrus Mistry as a chairman of Tata Sons. Supreme Court also said that the tribunal power under 241 with regard to oppression and mismanagement does not extend to the reinstatement of a removed chairman, that NCLAT does not have a power under section 241 to reinstate a chairman unless a removal is proven to be oppressive and prejudicially to the company and its member. Thereafter, Swiss Ribbon 2019 judgment is very important. It is not important for the Companies Law Act, but there are certain portion which deals under this judgment, which says it says the constitutionality, validity of Insolvency and Bankruptcy Act, and NCLT's role as a adjudicating authority, and that authority may be seen under Companies Law Act. So it says that it established that NCLT can set aside arbitrary decision of a committee of creditors. The committee of creditors with regard to the company taking a decision of any financial transactions or any financial business, the NCLT have a power to set aside that arbitrary decision. This is upheld in Swiss Ribbons Private Limited versus Union of India. So it is important for Companies Law Act. There is one investigating authority, SFIO. With regard to that, there are certain judgments. Ashish Bhalla versus State Delhi High Court said, once the SFIO initiate an investigation under section 212 of the Act, a parallel investigation by any other agency like economic offense wing into the small allegation is prohibited. So only the SFIO can take the charge for investigation, not other agency. No parallel investigation given to the other agency. So SFIO versus Aditya Sharda is a other case. In this case, Supreme Court in 2020 said that the anticipatory bail is a extraordinary power given to the court. So in a fraud cases, generally we have seen in company law, all offenses are non-cognizable except 447. It is a cognizable offense. 447 is mentioned under 212 clause 6, and that is why in everywhere we have seen that all offenses are non-cognizable except 212 clause, the proceeding under section 212 clause 6. So 447 is only a cognizable, all other offenses are non-cognizable. Non-cognizable here means that there must be some complainant, and that complainant has to be authorized by the central government, or the resolution if passed by the company, then the complainant maybe came into existence that can file a complaint, or any other specified authority prescribed by the central government. That is the way that complaint may be initiated against the company or erring officer of the company. The fraud is a cognizable. All offenses are compoundable in nature, wherein only fine is mentioned till 25 lakh is compoundable in nature, and that compounding has to be done while making a complaint, while making a application before registrar. First application must be to registrar by concerned authority, by concerned company, erring official must file application with the registrar, and registrar will make a compounding with that company, that erring officer. They will take a money back prescribed by the central government. If that authority, that company is giving money back, then that registrar will give application to the special court within 7 days. Within 7 days, intimation has to be given by the registrar to the special court that now, sir, we have already made a compounding with regard to that offense, and that officer, that erring officer, that company has already given us a money back, which is disputed money, which is fraudulent money. Now the special court give permission for that compounding. After compounding, all the proceeding will be struck down as acquittal of the accused. So other issue is whether a power of arrest is given to any authority under a Company Law Act. So only 447, if the offense committed by any person under 447, then the power of arrest is given to SFIO or other authority prescribed by the central government, and that power of arrest is with regard to certain types of authority, and that is why the person concerned may file a anticipatory bail. So in this judgment, SFIO versus Aditya Sharda, Supreme Court said that anticipatory bail is an extraordinary power when a arrest warrant are already issued under a Company Law Act. So then anticipatory bail cannot be allowed, generally not allowed, but in exceptional grounds it may be allowed. Court stated that the individual who have avoided legal process are not eligible for anticipatory bail. Court also noted that a special court has a discretion under 204 of a CRPC to issue either a summon or a warrant. The Supreme Court overturned the High Court's order granting anticipatory bail. So this case is all about anticipatory bail, the power of the court, and in what cases the anticipatory bail may be rejected. So other cases, Neetapuri versus Union of India, Delhi High Court. It says that order of assigning investigation to SFIO under section 212 subclause 1 subclause C must be mandatorily reflect the necessity in public interest. If there is a necessity in a public interest that investigation must be given to the SFIO under this provision, then only that SFIO can investigate. If there is no issue with regard to necessity in public interest, that proceeding, that investigation may be set aside. Actual circumstances need not to be there. There must be some material based upon which that investigation order may be given to the SFIO. There is other case law, IFB Agro Industries Limited versus Sigil India Limited. In this case, Supreme Court said the NCLT cannot use a rectificatory jurisdiction. What is a rectificatory jurisdiction? It says section 49 to adjudicate matter that fall under primary jurisdiction of SEBI. So it means you cannot rectify any authority to do these types of activity. You should not do these types of activity. So NCLT is a trial, as like a trial court. It does not give a rectificatory guidelines not to do or not to do that types of activities. So regulatory domain always given to the authorities mentioned under Company Law Act or other act. So this power is not given to NCLT. That is about this case. Thereafter we have done the case laws. Now I am shifting toward the types of authority under this act, and thereafter will complete each and every aspect of authority and what is the power of that authorities. We have seen there are 7 types of authorities under this act. One is a tribunal. Chapter 27 talks about two types of tribunal. There is a special court under section 28. There are regulatory bodies. There are investigative bodies. NCLT is a primary quasi-judicial body for civil corporate disputes, that is winding up or insolvency proceedings. NCLAT is a 410 says that it is a appellant forum hearing appeal against NCLT and NFRA orders. And special court is a section 435 says a speedy trial of criminal offences. So there are 407 is a section from which the chapter 27 is started. Talks about 2 types of authority. 4 and 7 is 11. It means certain authority. Thereafter, if you see 435, the special court, it also 538 8 4 12. So 11 12. There is a section 447 44 8 8 section 15. So these are the ways you can remember the section 11 12 are 2 types of authorities. And thereafter, just after 407 408 is talk about NCLT, and there is also a 410 talks about authority. These are the 3 sections talks about the 3 authorities. Thereafter section 2 subclause 75 a registrar of company, it is responsible for the registration and daily administration of the companies, that a company must take care of healthy transactions within the scope of company law. There is a regional director under section 458. It is a supervisory layer between registrar of companies and the central government. It is a layer between both of them. There are certain 7, currently 7 in number in India. There is a National Financial Reporting Authority under section 132. It is a apex body for auditing and accounting standard of professional misconduct, and we have already know the SFIOs. Section 407 says there are there are five definitions. First definition, chairperson. What is chairperson? It is a chairperson of appellant tribunal, who have already done. B is a judicial member. So judicial member is also in NCLT, also in NCLAT. So that judicial members are president, maybe a president, maybe a chairperson, or maybe a other member. It may happen. It may be a, so the word member is defined under clause C. It says there are two types of member. One is a judicial member, other are technical members. And president and chairperson also considered as a member. The word president is defined under section subclause D. It says a member means of a tribunal, and technical member means a member of a tribunal or appellant tribunal. These are the basic definitions, but they are very confusing in sense. So I have to check these definition while doing other sections. It is a judicial and quasi-judicial authority, NCLT. It having adjudication authority of all civil dispute relating to Indian companies, like winding up, white merger, like operation of minority shareholders. 409 says a specific qualification about a president, judicial member, and technical members. So I have already disclosed about the qualification of the NCLT. So we have to see like that way. Thereafter, the minimum age for appointment is 50 years, and retirement age is 67 year to the president and 65 year for the other members. So minimum age for NCLT members, member is president is also member, judicial member is also member, technical member is also member. So the minimum age of all authority, all the three authorities, minimum age is 50 years. So maximum age prescribed for the president is 67 and 65 for other members. In NCLT, NCLAT, it is appellant authority. Appeal against NCLT and appeal against National Financial Reporting Authority may be filed before NCLAT. 411 and 415 talks about the qualification of the chairperson, judicial member, and technical members who have already done. And the requirement age is for the chairman is the minimum age is always 50. So maximum age of a chairperson is 70 and a maximum age of other member is 67. 408 talk about NCLT, headed by the president, same as the civil court, not bound by CPC but follow natural justice. Appeal to an NCLAT may be filed within 45 days, and further 45 days may also be given with sufficient cause, and that matter which is pending before NCLT the NCLT, that 3 months, within 3 months from date of presentation or filing, that matter has to be completed, has to be adjudicated by the NCLT, and further 90 days may also be given if the president says that the matter is considering a very necessary in nature, and 90 days further may be given. So in a 3-month matter must be solved, plus 90 days may also be further given if NCLT find that matter is important. Bench always may be decided by the central government where bench is to be established. Generally in Delhi there is a bench. The principal bench is in Delhi. NCLT 410 is very important. It here appeal and headed by the chairperson. and can modified, confirm, set aside NCLT orders. Appeal always filed to the Supreme Court on a law point only within 60 days. And further 16 days with the sufficient cause, if Supreme Court find that there is a sufficient cause, that even after lapse of 60 days, further 60 days may be given by the Supreme Court. And NCLT must endeavor to dispose of NCLAT, never to dispose the matter within 3 months. And further from the date of presentation or filing. And after recording reasons, if chairperson of NCLT find that the disposal cannot be done within 90 days, he may also extend further 90 days for NCLT. It is the same as NCLT. It is the same procedure given under this section for NCLAT. So both authority have a power, same power to both, like High Court, to punish for contempt under section 425. It is already approved by the Supreme Court in a judgment, who have already done that judgment. Section 429 permit NCLT to request aid from local officials. NCLT can take aid, aid to deni padegi. That is a chief judicial magistrate or a district collector, to secure a company's property or book or document during proceeding of winding up or insolvency. Upon receiving such a request by chief judicial magistrate, chief metropolitan magistrate, or district collector, the authority of chief metropolitan magistrate is already done away by having a new law, BNSS. So it is authority may be seen a chief judicial magistrate only. CJM or district collector is bound to give aid to the National Company Law Tribunal with regard to the securing of property, books, documents, and that necessary force can also be used through the police by that authorities, the district collector and CJM also. So the primary function of NCLT is they take the suits under section 245, allow shareholders, depositor to sue for mismanagement. There is a mismanagement in the company. 245, it is also 11. 42665 11. So NCLT 407 11. 435 12. That is the way you can recall the sections. So NCLT deemed as a adjudicating authority for corporate insolvency in IBC. It also approves merger, amalgamation or conversion of public company to private through certain types of the proceeding. NCLT. NCLAT here appeal against the Competition Commission of India and National Financial Reporting Authority and appeal against NCLTs. There are landmark judgments on it. Tata Sons Limited, Cyrus Mistry have already been done by us, but the Mistry removal was illegal, held by the Supreme Court. Emphasized the protection of minority holders through Supreme Court later provided further clarity on a board's powers. There is one judgment, Arida versus Vari Energies Limited. In this says that NCLAT clarified that secured compulsorily convertible debenture holder are financial creditors, and they have a redemption clause as it represents the time value of money. Thereafter, Union of India versus R. Gandhi is a case. Supreme Court upheld that the constitutional validity of NCLT and NCLAT, but mandated that only high-ranked officials, secretary, additional secretary level, should be technical member. This is also one of the judgment which was decided by the Supreme Court in the same year when that previous judgment was decided, in which NCLT and NCLAT was constitutionally validated by the Supreme Court. There is a case Glass Trust Company LLC versus Baiju Ravindran and others. Supreme Court set aside an NCLAT order and used in which used NCLAT used inherent power under Rule 11 to approve 148 crore settlement between BIJU and BCCI. The Supreme Court said that NCLAT cannot use his inherent power under Rule 11 to approve these types of the settlements, which would have effectively ended the insolvency processes. So statutory procedure always have a supremacy. The court ruled that NCLAT cannot use inherent power to bypass the specific procedure for withdrawing insolvency under section 12A of IBC code. The committee of creditor is also there. Once the insolvency is admitted by NCLT, it becomes a collective process, and settlement cannot be reached between just two parties without involving broader committee of creditors. So the committee of creditors must be there while making a settlement. So in this case, the consent of the committee of creditor was not taken. That is why the statutory procedure which confirm the consent of committee of creditors under section 12A, so approved by the Supreme Court. And Supreme Court also dismissed the further appeal by Baiju, upholding that a subsequent NCLT order that mandated any settlement with BCI must first be presented to and approved by the committee of creditors. That is the power of committee of the creditors endorsed by the Supreme Court in this judgment. Now the other authority is a special court. This special court is established for the purpose of speedy trial under this Companies Law Act, presided over by a special judge or a magistrate, depending on the severity of the offences. Generally, more serious offences having a punishment plus 2 years or plus 2 years are to be handled by the session judge or a additional session judge that are considered as a special court, and that appointment is made by the concurrence of a High Court Chief Justice of concerned state. That any court may be considered as a special court by that central government or by state government, but the judge of that court, special court, is to be nominated by the central or state government through the concurrence of a High Court of Chief Justice. And that special court have a power to summarily try offences up to having a punishment of a 3-year imprisonment under section 436 clause 6, but sentence in that case cannot be given exceeding of 1 year. Summary trial can be done by the special court. There is a case Satyanarayan Bankat Lal Mallu versus Union of India. It says that deliberated on the jurisdiction of a special court established under 435, particularly regarding their power to try offences under insolvency code or company code, emphasize that there is a distinguish between graver offences tried by the session judge and lesser offences tried by the magistrate. Endorse that powers of a special court in this judgment. And there is a Kannan Devan Hills Plantations Private Limited was the Anthony Das. The Supreme Court again endorse the powers of a special court that is having a sole competency in handling complaints in Company Law Act. All offences are non-cognizable in nature, except offence referred to 212 clause 6. We have already done this. And police cannot arrest without warrant except in a specific serious instances like fraud under section 447. So there is no power to investigation agency to arrest any person except only in offence of fraud under 447. All offences are non-cognizable except 447. There must be a complaint for initiating a procedure under a Companies Law Act. The complaint must be filed by the registrar of the companies before the special court. Then only whole proceeding may be initiated as per the procedure given under BNSS, that firstly the summon must be issued to the concerned company, summon must be issued to the concerned hearing officer, may be treated as accused before taking cognizance. All the procedure BNSS has to be followed. So registrar can initiate the process by making a complaint. Shareholder or a member of a company can also initiate a process, complaint against a company, against a hearing officer. Person authorized by the central government or person authorized by SEBI, if the issue is with regard to transfer of securities and non-payment of dividends, can be issued by that authority before the special court. All offences are compoundable. 9444819. 9 is a noun. Ab मैं free. Compounding of certain offences. All offences are compoundable in nature. The application must be filed to registrar. That payment or credit by the company done. Central government specified by the authorities, NCLT, RD or authorized person from central government, and intimation given to the 7 days to the court. And thereafter, either by NCLT or by regional director or the officer authorized by the government, if fine imposed is not exceeding 25 lakh, then only compounding can be done. A compounding application always to the registrar. Registrar on the basis of that as the central government specified the authority, central government specified the authority, NCLT, RD, authorized person from a central government, they can file application before NCLT, through NCLT, through RD, through authorized person before central government, file a compounding. So offense punishable with imprisonment or imprisonment and fine are generally not compoundable. So unless the term may not be exceeding a 3 year, so up to 3 year, the offense are compoundable. When the offense is having a punishment more than 3 year, it is not be treated as a compoundable. And not exceeding 3 year is a compoundable, but compounding there is a certain procedure, and procedure has to be first application to registrar. Registrar forward that application before the NCLT, to the RD, to the authorized person, to the central government, and that authorities, NCLT can approve compounding, RD approve compounding, authorized person can approve compounding. Then the case will come to the special court. Special court can also approve these types of the compounding if authorized by NCLT, RD or authorized person from the central government, and within 7 days intimation must be given to the concerned court, special court. So NCLT cannot make a compounding, but NCLT take a initiative, facilitate the compounding process by intimating to the court that the compounding is done in my tribunal. So I have authorized that it is a good compounding, so you can give a acquittal to the hearing officer, hearing official of the company or company. Then only the court may stop the proceedings then and there. So there is a 442 reference to mediation panel. NCLT and NCLAT can refer the dispute to the mediation panel. That is recently made Mediation Act 2023. It ensure that every type of the dispute under Company Act can be solved by mediation. Can be solved by the mediation. The mediator or a conciliator may may conducted the all settlement proceedings between the parties and then give a order, and that order may be given to the NCLT or NCLAT. Then NCLT and NCLAT are bound for that mediation settlement unless and until there is a fraud committed against the party. So 443 power of a central government to appoint company prosecutor. These two sections are important for company prosecutor, since we are going to appear in the exam wherein the company prosecutor, the post of company prosecutor is also there, is also post for which we are giving exam. That is why these two sections are important. 443 says that the central government have a power to appoint a company prosecutor so as to conduct the prosecution in the company law. 444 says if there is a acquittal, then central government may direct the prosecutor or the authorized person within name or name of his office to file appeal passed by any court, that is a special court only, special court or judicial magistrate first class court, because the matter which is having a punishment less than 2 years may be triable by a judicial magistrate first class, even though a company act is involved in this case. So appeal to the, in this case, to the special court, and appeal may be against the acquittal, and that may be central government may be direct to the prosecutor to file a complaint. So 446B, the lesser punishment penalties for one person companies or a small companies. There is a one reasoning behind that one person company or small company may conduct a business by independence. They cannot be liable for a small types of compliance which they have not made during whole proceedings. It is because of by certain types of negligence or certain type of non informing about the certain law. That can be that penalties may be imposed upon them, but penalties are only not exceeding 1/2 of the penalties specified in relevant provisions, subject to maximum 2 lakh for the company and 1 lakh for the officer in default of. So in this provision, generally central government want to promote small businesses, small companies businesses, and that is why if there is non compliance of that officer of that companies, then there is a provision that no such high penalties may be imposed upon the said airing officer, said company, and that is why this provision is made under 446 clause B in the year 2022 by making amendment. It says that if a startup company, that is also one of a company, startup company, or a producer company or any officer in these companies making a default with respect to such company, or with respect to default with respect to certain minor offenses under this act, then fine may be imposed, but there is a relaxation with regard to that penalty, and that is all about 446 clause B. We have done all company law act. So there is a no need of any other things to be done under company law act for the purpose of exam. But if the candidates, if the person having a time, sufficient time, then he can complete, always do the definition clauses, very important. Then chapter 14 important, chapter 29 is very important, chapter 28 and chapter 27 are important. If you do not have a time to complete the syllabus, then you can done these 5 chapters: chapter 1, chapter 14, chapter 29, chapter 28, chapter 27, plus case laws, because more than 50% syllabus may be covered under these chapters. Other 50%, if you have a time, then complete all the law. But since it is a less days remain for the exam, that is why these you can complete these chapter firstly, then only if you have a time, then complete other syllabus. Thank you so much.